Hey, thanks everyone for coming. So for those of you online, we're doing this course out of St. George today. And my name's Jake Miller. I'm an attorney here at Vial Fotheringham. I've been with Vial Fotheringham basically since 2011 when I was a law clerk. I used to clerk with our Portland office. And then I moved out to Salt Lake City in 2013 and practiced here for about 5 or 6 years before I went up to Seattle, Washington. I was born in Washington State, practiced in Seattle for about 3 or 4 years, and then rejoined the firm, decided to leave the greater rat race of Seattle. And I missed Utah, so I'm back here since March of this year. So it's great to see some familiar faces and get, kind of reintroduce myself and come back into Utah. So as I mentioned to you folks that are here today, I am based out of Salt Lake, but one of our more senior attorneys, Karna, has a home here in St. George and should be getting barred with Utah probably at the end of October of this year. So we will have a presence permanently down here in St. George as well. And then I typically find myself, I currently have cases here in Cedar City and help HOAs all across the state. So it's never, a problem for me to drop down. And yeah, like I said, I like being here too. So in terms of the presentation today, it should be, 30 to 40 minutes, depending on how many questions we have. So if it's related to the slide, go ahead and feel free, if you're here, raise your hand and we'll get it across to the folks on Zoom. Otherwise, we should have a good amount of time for questions if they aren't specifically related to the PowerPoint. So just, save those. We can read some from online and do it that way too. So yeah, don't feel like we're in a time crunch at all, because I don't foresee that happening. One other thing I wanted to note, the Community Association Institute has a golf tournament here on October 4th, I believe. And so a lot of the law firms, management companies, take it, participate in that. It's a good way just to kind of meet other people. And I know we have Cedar City management here today. If you have some management questions, I think the rest of you are from boards that are here in person. Is that right? Any other managers today? So yeah, she's a great resource. And yeah, this one. We want to get video of me, not just a voice from the cloud. So yeah, so let's go ahead and get started. Hopefully you could see me there. I'll be kind of talking and walking. But if you can't hear me for some reason, just let me know. Bryce, do you want to move us to the first slide? So the title of this is Stay Funded. Right now the economy is changing and it's probably going to look a lot different for at least the next few years. As you've seen, interest rates have already gone up from, about 0 to a little over 2% now. Mortgage companies usually piggyback that with another 2 to 2.5%. And so we're seeing, rises in mortgage rates, which might, affect conveyances here in terms of like how quickly you can sell properties. It's gonna, your vendors might become more expensive. So we'll get into kind of the nitty gritty on that and just some things you can do to make sure that your HOA is, prepared for this coming forward. So we'll talk a little bit about inflation. My undergrad was in economics, but I'm not a financial advisor or anything like that. So, and I know it can be a politicized topic, so I'm just gonna try to keep it just to the economics here today. And like I said, feel free if you have a question here, just go ahead and raise your voice online. I think just to avoid feedback, we have mute on most folks. But if you have a question, type it into the chat, and you could just say something like, I have a question. We'll unmute you, and then try to get that in front of everybody, or you can type out your question on the chat. So here on the first slide, we have, what are the effects of inflation on HOAs? So like I mentioned, right now, federal rates are up to about just a little bit over 2%. As the Fed, in terms of their guidance, they're going to keep raising it for a while. Inflation's at about 8 to 9%. Whether or not it goes to match inflation, that's sort of the the economics, golden zone. I don't see the federal rate going up to 8%, but it wouldn't be out of the question, which would put mortgage rates up to 10%. So as a product of that, we're seeing wages go up. I was listening to a podcast on the way down here, and it mentioned that, we're seeing more service type vendors unionizing, we're seeing wages go up. And so one effect of that is probably going to be that, your landscape, maintenance folks, any kind of construction that you have done is going to go up in cost. So one question you should ask yourself is our reserve adequate, and is it prepared to handle some inflation? So as you probably know, in Utah, you're supposed to get a reserve study done at least every 6 years and then revisit it every 3 years. Now, that doesn't have to be done by a professional. It could be done in-house. But if a board can try as hard as they can to get it right, and maybe there's a CPA on the board or someone who knows how to do a good reserve study. But generally, if you're looking at a reserve study that goes over 30 years, it contemplates inflation at probably a steady rate, about 3% per year. So in the grand scheme of things, if your reserve analysis takes into account, inflation, you're probably good. There's going to be a spike in it now. You don't necessarily need to be really reactionary and just raise your rates right now because there's some inflation. In general, I recommend you raise your assessments, every year. But I wouldn't say to panic right now and just say, well, we need to raise them, whatever the max the board can do without having owners vote, or like we need to have owners vote in and approve a 20% raise right now. That's a little reactionary. Let's kind of wait and see what happens. But I do think, regardless, that things are going to keep getting a little bit more expensive. And if you aren't at least raising your assessments, even if it's a nominal or just a nominal amount, you should go ahead and probably do that. If you haven't done your reserve, and again, there isn't really an official penalty in the statute. If as a board, let's say you've neglected this, go ahead and get one done. I recommend, asking your management company to see if they have a person. Some management companies do them themselves, but potentially it's worth that investment to get that reserve analysis done. And especially if you're an older community and you're gonna have some expensive projects coming up, the costs of those are gonna go up. So just make sure, if you haven't done your reserve, do it and make sure it takes into account inflation. And then, definitely consider raising your assessments right now, but don't go overboard with it, I would say. Don't be too reactionary about it. So that's one effect, is your reserve analysis might not be adequate, or it might be fine, but that's something to look at. Another issue that you're going to see is, more defaults or potentially violations in your HOA because things are getting more expensive. So what I mean by that is there's so much equity in homes right now. And, generally job market's good that we're not seeing as many homeowners fall behind on their assessments. So generally collections has been kind of low, but as there's going to be more pressure, and, whether or not we're in a recession right now is kind of up to the economics and depends on which paper you read. But, inflation regardless is going to be bad and have a pullback effect on the economy. So even if we don't hit a recession, things are going to be more expensive for people. So if they're over leveraged or, they were just barely making their assessments now, they might start falling behind. And so if you don't have a good collection policy in place, generally after, you send them a warning letter after 60 days or 90 days, you want to lien the property. That's probably the most important, secure your debt. And then potentially look at turning it over to an attorney for collections. Our firm, generally we can do collections at no cost to the HOA. And what I mean by that is if you turn over the file to our office and you have an attorney fee provision in your declaration for collections, we can collect our fees from the debtor on the back end. Now there are some, caveats with that, and some HOAs prefer just to go hourly. But so that's something to look at, is don't be worried necessarily about attorney's fees associated with collections, because generally, most attorneys, like say other offices too, can take those accounts and we can recoup our fees directly from the owner. So the other thing that we're seeing already with inflation is, violations. So if you have a rental cap, people are having a hard time. They might try to start renting it out, and they might try to start renting it out to more people, than you normally allow. So generally with single family homes in any county in Utah, that's going to be head of household and maybe up to 2 unrelated people, or just a single family, servants, related by blood or whatever it is legally. So be kind of vigilant on if you start seeing a lot of traffic, a lot of cars coming in, that maybe somebody's violating those rules, which, may or may not be a big deal, but if everybody starts doing that, that's going to be an issue. If you pay for your roads and they're private, they're going to have more traffic on it. It's going to cost you more money. And basically you don't want to set up a precedent of, allowing that type of thing. And then people will also let, their own maintenance or upkeep slip. Maybe their yard starts slipping a little bit. They have to pinch their pennies, wherever they can. And sometimes that's okay. But at some point, these are fees, the HOA has to spend money to keep everyone's home in shape and keep it, fiscally sound. So what I recommend is just having a clear policy and then enforcing it. So another thing to look at are your vendor contracts. So I also do business law, and I have a landscaper client, and I just redid his contract, and he gets, landscaping contracts with HOAs. Those are one of his favorite clients because usually it's year round. And, up north, they can do snow removal. Here they might be mowing the yard all year round or doing groundskeeping. But one thing that I put in there, and something that you're going to see with, construction contracts or whatever it is they'll allow for variable costs, which means if their, supplies or materials that they need to buy to do the contract go up a certain amount of percentage, in his contract, I think it's 5%, that cost gets put on to the consumer. So you might think and budget for, let's say it's $1,000 a month for whatever these things are. But if they're, if they have to start paying more wages, or if, gas goes a lot higher, there might be triggers in that contract and you're going to be stuck paying for it. Maybe it goes up to $1,300 a month. So I highly recommend, with your vendor contracts to review them, and you can lock in people. I mean, this is all negotiable, but that's a potential area where HOAs could slip up right now and not be ready for that. So we have a question here in the audience. Yeah, go ahead.
I'm hearing what you're saying about variable costs. How does the HOA protect themselves from being gouged by a contractor?
Yeah, so our question is, how can you protect yourself from potentially being gouged under one of these contracts? So that's really going to come down to the contract language, and that why it might be nice to have an attorney involved, simply because we could put, limitations on that or caps that say, if you can't find materials that are within X amount of percent, let's say 10%, that the parties can, either one could just terminate the contract at that point, which isn't, it depends on where you are in it, but basically you can put in safeguards that limit that kind of variable cost. But if you don't have someone review it and it's kind of like a carte blanche for that vendor, you could be stuck with a bad contract. There are like anti-gouging rules in Utah, and it really come down to the language. And I think what you would potentially do too is ask to get their exact material prices and see if it's substantially the same as what you bargained for. But what I would probably want to do is put in some kind of clause that says, this has to be reasonable. We have to approve it if it's more than a certain percentage. So again, don't give them full authority to kind of get you, over the barrel with this kind of contract. It's just something to pay attention to. We have another question here.
I understood you were kind of indicating we should be avoiding variable costs in the contract.
Well, I agree. So not every contractor is going to put these in. I'm just saying, having seen it from the other side, that, yeah, you may want to avoid these kind of variable contracts in the first place too. And maybe they're willing to work with you on that, maybe they aren't. Normally, they're going to have in their vendor contract that if costs go up a certain amount, that they could either walk away from it or that the parties could terminate it. So it's something that needs to be negotiated, and that I recommend paying attention to. So yeah, whether or not you have to agree to one, it's probably the more sophisticated vendors that do that. But I have seen, construction companies got burned on this. And even if they don't have that clause and their costs go up, an exorbitant amount, they're probably going to breach the contracts. I mean, at some point it's not going to be feasible for them. And then you're in a legal mess that way. So it's just better to address it probably one way or another, whether or not it's with a variable cost or, some kind of ceiling and floor in terms of how much it can vary, if at all. And again, that's not going to be, some projects you buy all the materials right then, and it's not going to be an issue because you'll have everything in place. But if it's, ongoing, it's done in phases, that's where you're going to see an issue. And so we had one, comment from online that said, 3 national vendors I currently work with charge a gas fee in addition to the contract, which I think is probably pretty reasonable. But again, if gas, California is $7 a gallon in some places, and if they're, doing a building pad or a lot of work that requires like a lot of trucks, I mean, that could really change the face of your contract. So something to keep in mind there. I also have capital improvements here. So usually, ours will define what a capital improvement could be. So if it's, either dollar amount, so any projects over $10,000 or like X amount of the assessments, that requires, homeowners to vote on it, or that it's something that the board has to take certain steps to get approved before you can just go and move forward with that project. So something we're probably going to see with inflation is those are going to get more expensive. Again, with materials going up, with the wages of the workers going up. So, if you're going to have to replace like a common roof or get a lot of work done on a clubhouse, and you're assuming, prices from, let's say, even last year going forward, that might not be good enough and your reserves might be short. So I think there's a few things you could do just in terms of, assuming those are going to be more expensive. If you can lock in a good price now, maybe look at trying to do those, move those up if you can. Mostly it's just something to be aware of. Also, I have listed on here conveyances. So with mortgage rates going up, I mean, a lot of people, one effect of inflation is that asset values of homes has also been inflated, which, is great. As a homeowner, you're like, yes, look at all this equity. We were just looking at a property that one of my friends bought in Salt Lake that sold for $750,000 in 2018, and they just bought it for 1.3 million. So I mean, that's crazy, right? I mean, that's a ton of equity, and a lot of sellers that are like, hooray, this is going to solve all my problems. I just made so much money on this. But keep in mind, with rates going up, and if the home's going to need a lot of fix, or like, again, let's say it's in one of your HOAs and you have to hit a big special assessment because, it's townhomes and you need a new roof on everything, that equity can get eaten up really quickly. And so I hear a lot of homeowners right now are kind of banking on, all this equity that they have, but that's not necessarily going to cover everything. And I've seen, I was working on some properties in Seattle and in Oregon, and, some of these beachside homes got hit with $40,000 special assessments because everything's so expensive right now. And so there you have a hard, maybe it's going to be hard to sell that property. Maybe the sale goes south and people start defaulting on their special assessments. So something to keep in mind is, a lot of these things are going to be a lot more expensive. And conveyances aren't as convenient as they were. Right now mortgage rates are about 4.5%, but that might keep going up. So another bullet point I have here is a utilities increase. And I think this, this applies throughout the whole state, but especially down here in St. George. Water is going to get more expensive. You haven't really seen it yet, but with, we're in one of the fastest growing states. in the country. We do live in generally pretty arid land. Taking water from the Colorado River is going to get more expensive. They started to meter secondary water, I know in Davis County in northern Utah. And so if your HOA uses secondary water, chances are it's going to be metered throughout the whole state. They said that's not going to increase the price, but eventually it's going to. And the best way to get people to use less water is basically to bring up the price of it. So that's something to take into account, is that water is probably going to get more expensive. And so, if in your reserve, and again, if you have separately metered homes, this probably isn't a big deal. That's going to be on the homeowner. But, if you are paying for water as an HOA, that's something to keep in mind, that you need to raise your assessments. But again, higher water fees, even if they're metered separately, is going to, impact that owner's ability to pay. So these are some of the things to consider with inflation. I see rates probably continuing to go up for at least the next year to get inflation down. Whether or not they'll stay high, I don't know, but they've been low for 10 years. So chances are they're going to be higher for a while. So those are some things I have to consider with inflation. I think we have a question from online. Oh, yeah, we have kind of a specific one that someone asked, and I will get to that question after the PowerPoint. So we do have that question. I think it came from, was it Courtney?
Randy, thank you.
Yep, no problem. So Bryce, if you want to go to the next slide online, I want to make sure we're on the same page here too. So staying a step ahead, one of the biggest things you can do, so I mentioned raising assessments, but if you don't have one, you should really look at getting a reinvestment fee. These used to be called transfer fees. They updated the statute a little while ago, so now it's called a reinvestment fee. Do you know, here in the audience, do any of you have a reinvestment fee? So look, almost everybody does. And you probably know what it is, but you'd be surprised at how many HOAs do not have one. And so what a reinvestment fee is when the property is conveyed, as long as it's to an independent party. So, if you're going to pass it down to your kids or something, that won't trigger. But generally, 99% of conveyances are to, a perfect stranger. So the reinvestment fee will kick in. And that's in Utah, it's legally can go up as high as 0.5 percentage point of the sale price of the home. So if someone sold a home for $500,000 here, technically the reinvestment fee could be as high as $2,500. And what that fee does, it's normally paid by a buyer, but it's negotiable. A seller could do it too, or they could lower the price. Is all that money basically goes back into the pot for the HOA, and it's to cover things like, you have to update your records when you have a new owner, maybe you release a lien, whatever it is to get them back on the books. And I know boards aren't paid, but this is basically, we're going to use some HOA resources to get this new owner in here. So it covers things like that, but also in general, this is kind of an advance on assessments to make sure that the HOA is in a good position. So what I do when I draft these is say that the HOA can charge up to that 0.5 percentage point, but that you need to contact the board and get the exact amount. If you have a small HOA and the reserves aren't that big and you don't have much common property or clubhouse, this should probably be smaller than the 0.5 percentage point. What might be fair, then might just be $250 or some kind of flat amount. But if you aren't charging this, and homeowners don't always want to stomach higher, like new assessment fees that are higher, this is a good way to kind of get around that. But again, I think it's for a good purpose. And owners don't usually push back on this, because when you're buying into an HOA, it's just kind of like you're paying into what you're already buying into. So it's usually not a hard sale, and it's such a small amount when we're talking about hundreds of thousands of dollars. A few $100 or maybe $1,000 isn't a big deal. So generally, we do not see any kind of pushback on reinvestment fees. So if you don't have one, you should really look at getting one. So there's a couple ways to do it, and the best way to have a reinvestment fee is if your declaration specifically allows for it. Then all you have to do is get it recorded. So that's the key thing, is if a reinvestment fee, if there isn't a notice that's recorded against all the properties in your HOA, it's not going to be valid. And the title company's not going to see it, and they're not going to know to pay this when they convey the property. So it has to be recorded. To make sure it's recorded. Now, the other thing, and there's a little bit of debate about this, I cite to the statute for the reinvestment fee here, and it says UCA, which is Utah Code, annotated 57-146. So if you Google that, you'll see it. And it says a reinvestment fee covenant means a covenant, restriction, or agreement. So normally your covenants are going to be in your declaration, but, and what I've done for some HOAs is, look, it says you can pass this as a restriction or an agreement. So in my opinion, and again, it's better if the declaration expressly allows for a reinvestment fee, but if it doesn't, that you could promulgate this as a rule, go ahead and record it. And generally, I haven't had any pushback from owners on that. So I think there's a couple ways to do it, and it depends slightly on your risk tolerance, but I don't know of any cases in Utah where people try to challenge reinvestment fees, you know, if it's not in your declaration and won, because generally it's just not worth it. When you're busy, when you're trying to sell your home, people are going to pay it. It's going to keep the HOA, you know, solvent and in good shape. So really, if you don't have one of these, and it sounds like everyone here, at least in St. George, has one, look at that instead of raising up your fees, or make sure you're charging them, make sure they're recorded, and maybe look at raising them going forward. So on this slide, I also mentioned budget for the economy. So we kind of already went over this, but you know, expect delinquencies. That should always be part of your reserve. And you know, maybe it's not as big of an issue down here as in some other places, but generally you're going to have some homeowners fall behind. I actually have 2 foreclosures that I'm doing here tomorrow where the owners passed away, but then the homes got stuck in, basically they didn't have a will. No one's been paying anything. We've actually had to move forward with a foreclosure just to get new owners into that property. You know, and it's stuck in probate basically. So, you know, things like that can happen. And so just be prepared and expect that one way or another. Most, you know, larger, especially condominiums, like you're going to have delinquencies almost all the time. Review your reserves. Again, just make sure you're in a position where you're going to be, what you'd like is to be 50% funded, which that means in your reserves, you have at least what you consider to be half the amount of money you're going to need for any projects that are upcoming that are, you know, within your purview. So if you know you're going to need a new clubhouse in the next 5 years, that's going to cost, you know, $50,000 or whatever it is to modify it. It'd be great if you have at least, you know, half that amount of money sitting in your reserves or will by the day that you have to do it. So 50% is kind of the benchmark. You know, sometimes it'll be 20%, sometimes it'll be like 80%. You have a really great reserve. I would say, you know, just kind of aim for at least that 50%. And so one other issue with inflation right now is obtaining loans. So if your HOA does need to get a loan to pay for, you know, capital improvements or whatever it is, if you have too many renters, so people who allow renters in their unit, especially over 50%, banks are going to be really weary to lend you any money. Or if you have, you know, other restrictions or too many homeowners that are behind on dues, banks aren't going to lend you money. And as money gets more expensive with inflation, again, we're going to see higher interest rates. They're going to be more stringent on who they loan money to. So again, you know, some HOAs need to get loans to pay for these things, some don't. But if you think you're going to have to get a loan, you need to be in pretty good shape before you move forward with it. So let's go ahead and move to the next slide. So fine schedules. So again, you know, when the economy is good, generally people are pretty compliant and are willing to spend the money to, you know, make the HOA happy. But we do start seeing more, you know, potentially bad behavior or something that violates the rules. So one thing that I recommend you do, so generally your schedule of fines and your rules should not be in your declaration. You know, in old ones, they tend to be in there. The problem with that is when you have to go amend your declaration, you have to get at least 50% to 2/3 of the owners to approve it. And so what's easier is if you have your rules that are separate, the board comes up with them, generally presents them by the homeowners, and that way they're a lot easier to change and can reflect, current times and not have to require an amendment of your governing documents. So if at all possible, I'd say try to make your rules separate, something that's not recorded. So something that you post up on your website, send to all your owners. But one thing I've been seeing is a lot of people still have fine amounts from, the early 90s that, if you're renting your unit, you shouldn't be, maybe they get fined $200 a month. I mean, that's really low. And generally they can make that up just by renting it. So it's not going to be a penalty that changes their behavior. So what I recommend, if someone's illegally renting is, fine them up to as much as $750 a month to, $2,000 a month, depending on where you live, to make it, a penalty that people actually respond to. Another thing we're seeing with COVID and just, the nature of work right now is a lot more people are working from home, in which case that's generally okay. As a lawyer working from home, it's not a big deal. I'm just on my computer. But if they're starting to increase the traffic to the HOA or running a daycare or doing something maybe they're not supposed to, keep an eye out for that. And make sure that you have a rule that, spells out, you're allowed to work at home up to, whatever the county says is a good at-home work. But if it goes beyond that, if they're running a bakery out of it or maybe they're a psychiatrist and have people coming all day, you don't want to allow that in HOA, basically. And then the other big thing I see is with vehicles. So if parking's an issue, generally you can try to control it by just allowing a certain amount of parking passes per property. But if they're, renting and have 4 or 5 cars there and no one can park, that can become an issue too. So just make sure you have clear rules on vehicles. You might want to get, license plate numbers of everyone that's living there. It's just a good way to keep track of it. Again, mostly just an issue if you allow rentals, period, within your HOA. And one thing I wanted to mention here is passing rules between condos and community associations is different. So condos have more power to pass rules just as a board. You don't have to necessarily hold a meeting or give notice to owners. If you're in some townhomes, they can be set up as condominiums or as community associations. So be careful. It's not always clear cut. Condos can pass rules a lot easier, but they're capped to $500 per month per violation. You're going to see a lot more of, especially here in St. George, are community associations. So it's a little harder to pass rules in communities. And I cited the statute here, it is 57-8A 217. You have to provide basically you have to hold a meeting with the owners as a board, give at least 15 days notice that you're going to have a meeting about doing new rules, discuss the new rules there. Then the HOA can, there doesn't need to be a vote. The HOA, the board can confirm, send out the rules and start enforcing them. But then the homeowners have a 60-day period where if 51% of the total owners of the community association decide that they don't like those rules, they can overturn them. So just be careful. I do see community associations where they just pass rules, kind of like a condo, where they just say, hey, here's what we're going to do. You have 2 weeks before we start employing these rules. You need to basically have this 15-day notice and a meeting before the community association can pass rules. And the problem there is if you go to enforce it and someone says, I don't think this is a fair rule, they're going to look and see if it was promulgated correctly or not. And if it wasn't, that rule just might not be valid, and then you're in a world of hurt, basically. So that's something to keep in mind. I did a presentation on some of the new laws that came out that went into effect in May. But if you're not aware of them, there's new rules on signage. You have to allow people to have a for sale sign, a political sign. You can't ban it. Certain holiday displays. Your shall is the operative word. You're supposed to pass rules about xeriscaping. So if you haven't, again, we don't know what the penalty is going to be on that. But you need to make sure that you have a rule that basically says xeriscaping is okay. You can't flat out ban it. So if you have questions about some of the new laws, just let me know. The other one is with electric vehicle charging stations. And so those are some of the big ones. So if if that's news to you and want to make sure you're compliant, let me know. And we could make sure that we get those rules passed for you. And then I mentioned this, particularly because we're here in St. George, is the new zero-scaping rule.
You did have a question on the financial stuff?
Okay. So the question from Desert Edge?
Yeah, is that?
Yeah, so here, I'll go ahead and read the question we have. It says, can you please provide more information on examples of collateral to be used by HOAs when taking out a loan? Can you explain how this will work when an owner sells their unit? With a special assessment, the current owner is responsible to pay prior to selling. However, how does that work with a loan? That is a little specific. Generally, it's not going to affect a conveyance. So if the HOA has a loan out to do a capital improvement, they can still convey units within that property. In terms of the collateral, so they might have an encumbrance on the community property. It really depends. So, but that's a question I could get into probably after I present on this. But that's something to keep in mind. If you have an HOA looking to get a loan, I can fill in a little bit on that. So, so back to zero-scaping. So you have to allow homeowners to zero-scape right now. You can't flat out ban it. So the way to get in front of that is to make sure that you have a review process in place. So you don't want people, if you don't want like AstroTurf or just to gravel their yard and not put in any native plants, you should have some kind of design criteria put in place so that before they go zero-scape, the board still has to approve that. Just like an architectural control committee, you want to make sure that basically homeowners are zero-scaping, but they're doing it in a way that's going to preserve values and keep the HOA looking like how you want to make it look. And one thing I noted here is if people are not complying with this, let's say a homeowner does zero-scapes and the board would not have approved it, instead of maybe fining them, you can file what's called a notice of non-compliance, which still encumbers the property, but it's not a lien for a certain money amount. It's a lien that says before you sell this, you need to get the yard taken care of. So if you don't want to have kind of a knockout battle with a homeowner and say, look, we're okay with the zero-scaping for now, but whenever you convey this property, it has to come in line with what the HOA wants to do. That's just another tool that you can use to make sure that that homeowner becomes compliant. So consider, and this is something I always try to raise with my HOAs is, instead of doing a lot of fines and making it really acrimonious, let's agree maybe to be like, okay, this isn't in compliance with the HOA, but before you go to sell it or whatever you do, you're going to have to come in compliance. So that's called a notice of non-compliance, and it is recorded against that specific property. So moving to the second to last slide, I'm going to steal some of your water, Bryce. So again, we have a question here.
The substation owns our grass and our property. So if a homeowner wanted their front yard zero-scape, it's not their land, it's our land. And we can't, and we aren't ready to do that yet. We can do that, right?
Yeah, so the question here with the zero-scaping is what if the HOA is the one that owns all the landscaping, which is pretty common,
Right.
And it's not an individual owner. So generally, yes, the HOA is going to be able to decide how to handle that. What I would recommend is maybe hold a meeting with the homeowners that says, look, the water is getting really expensive. We're paying for it. We want to reduce our impact and intake of water. Maybe hold a vote and says, let's decide if we want to zero-scape it or not. But one single homeowner can't hold you as a board hostage on that. it's a little different, and you need to be careful if it's limited common area. So if it is specific to that unit, then yes, even if it's part of, maybe connects to neighbor's grass or something, gets a little dicey there. And you may have to allow that homeowner to do the xeriscaping, but you're going to control how it's done. So make sure it is, common area versus limited common area. And then I would just come up with a plan in terms of all the HOA's landscaping. And do you guys have you guys looked and seen what they mean by water-wise landscaping? So a lot of it is just getting rid of, irrigation that has sprinklers pop up. Basically try to do native plants, just have like a drip line or occasional watering. The other thing I'd recommend, we've got a fair amount of thunderstorms, at least in Salt Lake, and we had a pretty good soak the other night. So make sure you're turning off your water, after a storm. Have someone, maybe even a board member, just be in charge of that. I don't think you necessarily have to pay a maintenance company, or they'd be worth it. But, really try to conserve water if you're paying for it as a group, that way. And we have a couple questions here in the audience. So yeah, go ahead.
So going with the xeriscape before, so the laws that were passed by the state, are they going to mandate that HOAs do some xeriscaping or not?
All right. So the question here is, with the new laws, is the state, and these are under, the Community Association Act, and they also apply to condos, which is a little more complex. But are they going to mandate any xeriscaping? So as of now, no, there's nothing mandated. But the only thing it says is you can't pass a rule that says nobody can xeriscape. So it's a little clunky, I would say there. But basically, if it's limited common area, or if it's, the specific owner has rights to that land, you can't stop them from doing it. But there's no requirement that HOAs do it. Maybe you've seen in the news, your neighbor to the south, Las Vegas, is basically very aggressively getting rid of grass strips. I could foresee something like that happening here. But as of right now, no, there's no requirement for it. But again, I think as Utah grows and water gets more expensive, you really might see them limit, grass strips, period, to where, they have a strip for pets. But if it's not being actively used, that could eventually, you're going to have to tear that up. So we'll see. We're not there yet. CAI, I can tell you, at least we haven't discussed that aggressive of a law. But, you never know. It changes every year. And, depending on how bad the drought is, or if it continues, it might get that way. And I could see even on a federal level, with St. George, and they pull water from the Colorado River here, is that might get, a lot more stringent on it. And, St. George may have to look at other resources or whatever it can do, and maybe not have yards. So, we had another question here on xeriscaping too.
The notice of non-compliance that's recorded against the property, is that something the HOA can accomplish, or the property manager, or does one need an attorney to write that recording?
So the question is, I've mentioned that notice of non-compliance, and is that something that the HOA or board or management company could do itself, or is it something that they would need an attorney to help them with? So it really kind of depends on the sophistication of the board and the management company. Some management companies I know do their own liens and get them recorded, and people in the recorder's office are pretty helpful and can help you do that. The notice of non-compliance, I would say you should probably use an attorney, because it's going to have specific language to that problem. So like a money lien, if you know how to do it and you have an active ledger, that's pretty easy for the board or the management company to do itself if they're accustomed to doing that. Well, but notice of non-compliance, you're going to have some language that says, here's the exact rule, maybe it's landscaping, that you're not following. Here's what you have to have done before you convey the property. So again, it's something you don't have to have a lawyer sign those. So if you're comfortable doing it yourself, you can. I'm going to think that you're probably going to want an attorney to help you with that. And then maybe the board takes care of the recording itself. If you take the document to the recorder's office, that's pretty straightforward. So there isn't, it's not required to be an attorney, but it is a little bit complex. And to make sure you have it done right and this report against the right property, you probably want to use an attorney. So we have another question. This one comes online about the notice of non-compliance. It asks, is this something covered by statute? And does an HOA have to amend CC&Rs or adopt a rule that allows such a notice as an alternative to fines? So no, this is independent. The notice of compliance is independent of your governing documents. It's just a remedy that you have available no matter what. So no, you will not have to pass a rule discussing it. It doesn't have to be allowed in your CC&Rs. The non-compliance notice is just a tool that all HOAs have. And I think I've caught up on the questions here. So, and again, not to beat a dead horse, but I have collection and foreclosure policies listed here again. Just to reiterate, your assessments are the lifeblood of the community. That's how you get anything done. So it's something that when you start seeing, I had an HOA, and I don't think they're represented here. I'm not going to say who, but during COVID, they basically weren't doing any kind of collections because they felt bad. So people fell behind on their bills, which, okay. But, is that something that's fair to do to your other owners who are paying? So what I recommend is you just have a very straightforward policy. It says if you're 60 days behind, or whatever it is, or a certain amount, you get a warning letter, and that, we're going to lien your property, and we're going to turn you over to the attorney after, a certain amount of days or amount of fees. And again, it's up to the board. You generally have discretion if, they've had a hard time, maybe death in the family, you don't want to collect on it. You don't necessarily have to, but you should have some notes explaining why. So, and again, with collections, remember, you should always be in executive session. You do not want to discuss these in front of other homeowners. That's kind of like giving someone the scarlet letter. That's sensitive information. So as board members, whenever you're discussing any kind of litigation or collection, go to executive sessions. You don't have homeowners there, and you don't have to note the very specific names. Just say going into executive session to discuss collections. And that's all you need for your notes. You don't need to have, because again, that could be discoverable in litigation, and we don't want that out there. So, so go ahead and go in executive session, have a policy. If you don't have one, that's something we do. We draft it up. We say, here's exactly what's going to happen. Here's what the lien's going to look like. Here's a sample letter. And then really, if you have a good policy, the board can do a lot of that themselves until it becomes time, or the management company, until they actually have to file a lawsuit if it gets there. There tends to be three kind of debtors. And this is not specific to HOAs, but there's the ones that you'll tell them they've fallen behind and they just get paid up. It was a mistake, or, maybe we needed a month or two off. Here's your money. There's the other ones that they're not going to pay until an attorney gets involved, or if they get a lien on the property, because then they can tell it's getting serious. So, maybe they get that lien notice or, a lawsuit from attorney, it gets paid. And then the third kind, they're never going to pay it unless you come and take it. So you're going to have to go through the whole process, sue them, get judgment. Then you could consider foreclosure, or, garnish their wages, garnish their bank accounts, which I know sounds kind of nasty, but that's, why you have us do it. You don't do that as a board or as a management company. So again, if you don't have a clear-cut policy, the expectation is with inflation that we're going to see more type of collections work coming down the pipe. And so here, and I don't know, I do see HOAs actually pretty commonly. They're still operating under their governing documents that be declarant drafted. So there's been a turnover. The developer is no longer involved, but all the documents really favor the developer. And maybe they don't have the language that helps the board get done what they need to do. You don't have freedom to promulgate rules. You don't have a good collection policy. The developer wasn't probably worried about that. They just want to sell units. So if that's the case, you really need to look at your CC&Rs to make sure that you can, collect against homeowners, pass rules for collection. So just something to consider there. Another issue I've been seeing a lot is your interest rates and your late fee provisions. Some HOAs are still stuck charging $5 a month as a late fee. Is that going to be very effective? Probably not. Maybe sometimes those add up. And then also, what is your interest rate? Pretty common here. What I recommend is anywhere from 12 to 18% per annum. So, you're looking at about 1% per month. Judges will uphold that. I've seen as high as 24%. The federal rate's going to be pretty low, probably under 6%. But make sure that it's a decent penalty to actually, incentivize people to pay. And, late fee, what I like is to say a percentage of whatever the assessment is. So let's say it's 10%, because then it doesn't matter if your assessments are raising, it's always going to follow with it. You'll be ready to be there. A lot of times there'll be specific amounts in your declaration, so you have to stick with those unless you amend it. A good declaration will say the board sets the interest and late fees from time to time. Then just do a new promulgation of like, here's a new collection resolution that says, here's what our late fees and interest are. So make sure you have those in place now. If you have a lot of homeowners that are behind and let's say you have to get their approval to raise it, that's not going to happen. So you just want to get in front of it. And hopefully this isn't going to be the case. You're not going to have a lot of collections, but I've been in this business for over 10 years and I was collecting on debts from 2008 up until, I've had some cases where we still have it basically from debts from back then. So these things happen and it's unfortunate, but you do need to be prepared for it. Outside of those rates, the other big issue are the turnover period. So, you should say if you're 60 days late or you're this amount behind, you get turned over to an attorney and or the management company, and just have a clear rule. Again, I do have HOAs and I think their heart's in the right place, but they're kind of like, well, you're at $1,200, let's turn you over. It's not a bright line. That can look like favoritism to certain homeowners. Maybe there's conflict with the board, you're friends with them, so you don't want to collect on them. So I highly recommend you have a very specific turnover date for collections and that you just follow through with that. So I'll go back. So that was kind of my last slide of substance. So like I said, we have a fair amount of time for questions. And if they are, really specific, that's something. You have my email address there. So I totally welcome you to, shoot me an email or give me a call. Probably starting Friday. I'll be driving back up Salt Lake tomorrow. And I can get those answered for you. I can send anyone who wants a copy of the slides. Let us know, and we will get those emailed out to you. And I'm trying to see, Bryce, do you have any questions from earlier that I can answer? Oh, so here, I'll go back to the question from Randy, which I promised I'd get to. It says, we are a cabin community. Our documents allow for cabins to be rented, but the two properties who rent do use the roads, parking lots, etc., to a greater degree than the other owners. We're going to allow each owner 4 car tags. The one person who rents out his cabin many times in the winter has 10 or more in our limited space parking lot. Can we, 1, charge him more because of his use for the roads? 2, limit him to 4 car tags like we do everyone else? He says he will sue us if we do. Okay. So yeah, you are empowered to make these kind of restrictions, and you absolutely should. Homeowners always say, oh, I'm going to sue you, unless I don't get what I want, or they don't, they're used to not living in an HOA and doing whatever they want with their properties. So that's not going to fly. And almost every declaration has an attorney's fee provision. So if someone sues you or you have to sue them to enforce something and you win, guess what? You're almost guaranteed to get your attorney's fees against them too. So when homeowners threaten suit, you have to let them know, like, look, this isn't, you can't just sue us and there not be a consequence. And again, it could be a hassle. I don't try to get HOA sued. I try to come to a good, mutual decision that makes sense for everybody and is fair. But here with, if he has that many homeowners on a road, and I know, I have some clients around, Bryant Head and up in Park City, where yeah, that is an issue. And if they're private roads and they're using that many more people on it, I would go ahead and pass a rule. Again, it's going to depend on exactly what's in your CCNRs. So I can't tell you specifically, was it Randy? Randy, in regards to whether or not you have that authority. You probably do. The big thing is to avoid trying to pass a rule that targets a specific homeowner. So let's say if his name's Tom, you don't want the Tom rule that says, all right, we're going to limit cars to 4 just because of this one property. It needs to make sense against all the homeowners and treat them equally. So I would have to look at your documents a little bit, but chances are you could pass a new rule. And as part of it, I would say, here's why we're doing it. We want to avoid too much traffic on our roads. It costs more money, and go about it that way. But it might be specific to the situation and whether or not your documents, what authority you have to pass rules exactly. So that's something I would take a look at. But don't be afraid of homeowners if, they're going to sue you. I would just say off the bat, that's not a good reason for you not to, act as a board and make rules that, save everyone else's money and really preserve the integrity of the HOA. So I think that's about it. If anyone online has any other questions, feel free to type them in. If they are specific, shoot me an email. We could set up a time to chat. Any more questions here in person right now, or you come talk to me after as well. But I really appreciate you all joining us. I hope this was helpful. And again, if you want a copy of some of the slides, we'll get that over to you. And yeah, thanks again.